Look, may I complete?
10 minutes.
Yes, Manoj.
And half an hour, and 3 o'clock we'll start the other.
Yes, Manoj. So 2 points, Manoj, as I will be addressing your lordships today
By the clock.
by the clock. 2 broad submissions. The first submission I was on, my lords, is on 8. How is 8 to be understood?
Yeah.
The second point that I will be making later on, my lords, is on how the Act being a complete code, Section 5 will come to the aid of a judicial authority when confronted with an objection raised on the basis of a document being unstamped or inadequately stamped. So 2 submissions that I'm making. The first submission while I was making before lunch, my lords, I was using Section 45 to show you how 8, my lords, is a departure, and therefore there has to be specific meaning given to the departure made by Parliament. 2 submissions that I made, my lords, prior to lunch. 1, 45 in its original avatar was drawn from the New York Convention. In 45, my lords, when your lordships were looking at it, your lordships in Shinetsu interpreted unless it finds to be a prima facie determination. It did not require an elaborate trial, although that point of view was canvassed by one of the opinions, but that is the minority opinion of your lordships. The majority opinion, it preferred a prima facie determination. Now, when that was a view that your lordships took in 2007, when Section 45 did not even have the expression prima facie, today your lordships has the benefit of the expression prima facie in Section 8. It is all the more reason that your lordships will adopt the Shinetsu approach when your lordships looks at Section 8. This is one. Second point, my lords, would your lordships take up Section 8 in the bare act? In the bare text, kindly see in the footnote to 8 is how 8 originally was when the act was enacted. And this, my lords, is very interesting because under Part 1 of the law, when we made the provisions, we were supposed to draw inspiration from the Uncitral Model Law. In Uncitral Model Law, Article 8 mirrored Article 2, Sub-Article 3 of the New York Convention. They had the same expression, null and void, inoperative, or incapable of being performed. When Parliament enacted 8, it completely discarded that expression. There was no exception for a judicial authority. Kindly see the footnote to my lord, Section 8. This was the provision as it originally stood. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so applies no later than submitting his first statement on the subject of, refer the parties to arbitration. There is no exception. The exception was in the Uncitral Model Law. Unless it is null and void, inoperative, or incapable of being performed. So, my lords, from one extreme, which is under the Uncitral Model Law, when Parliament made Section 8 originally, it travelled to the other extreme, saying we will not allow any exceptions. There is a judgment, my lords, of your lordships called Anand Gajapati, my lords, Anand Gajapati Raju, 2000, Volume 4, SCC 539. Where in view of this, what your lordships interpreted and held was, Section 8 is peremptory. If a reference is made relying upon Section 5 read with Section 8, your lordship's view was, it is peremptory. If a request is made, you shall refer. There were absolutely no exceptions under 8. Now, my lords, what now has happened is in 2015, a middle path is now taken by Parliament. So Parliament could have said, we will adopt bodily null and void, inoperative, incapable of being performed. It didn't. It made it peremptory. Now it says, unless it finds that prima facie no valid arbitration agreement exists. So it's a middle path. Now, Malad, the choice of expression in the middle path is the next thing that I want to emphasize on. Parliament is aware in Part 2 of the legislation it has used of phraseology, but in Part 1 it is deliberately now using only one expression, validity. No valid arbitration agreement exists. So it's aware that an arbitration agreement may be existing, but the judicial authority is bidden to give a prima facie examination to validity. Now, why I say this, my lords, with utmost respect, Parliament under Section 8 now, post 2015, is aligning it with section 16, because section 18 also uses the same expressions, existence and validity. Once Parliament is saying under section 8 as it now exists, prima facie, please see, prima facie no valid arbitration agreement exists, and then 16 always has existed, where a tribunal can, exercising competence, look at existence or validity. The scheme is very clear. In 8, please make a prima facie determination, leave the rest to the tribunal. What is, my lords, to be additionally noted is two aspects. Section 45 begins with a non-obstante clause. So 45 requires your lordships to not be colored by anything in part 1. Notwithstanding anything in part 1 or the CPC. That's how section 45 opens. So when your lordships is interpreting null and void, inoperative or incapable of being performed, they are standalone. They cannot take strength from the other provisions used in part 1. Why this is important, my lords, is, now take, my lords, a situation at hand which is a temporary affliction because of stamp duty. Now, my lords, on a plain reading of the scheme of the Act, it does not destroy the document. It's a temporary affliction.
It is a temporary, what do you call it?
Affliction.
Affliction.
Affliction, my lords.
You violate the law and you call it temporary affliction.
No, my lords, for the reason that the Act itself says, the Act, and as your lordships have interpreted the Act, in Hindustan Steel, the expression used is, Act is a fiscal measure enacted to secure revenue for a state on certain classes.
The unstamped document which you described as a temporary affliction.
For the reason, my lords.
Engage the attention of a civil court.
Yes.
And the civil judge.
My lords.
Sees that it is not stamped.
My lords.
What is his duty?
Yes, my lords. I'll address my lords. I'll address my lords.
Will it be a temporary affliction?
I'll address my
If the
lords.
stamp duty is not paid,
I'll take several parallel illustrations.
all within 2 minutes.
Then, yes, parallel illustrations. Illustration 1. Illustration 1. And I'm on 45. Kindly see your lordship's judgment in Vijay Karya.
The 45, we are not concerned with 45.
For the reason, my lords, I'm on a better footing there, so 8 can't be worse.
We are talking about 11. We are not
Very well.
on 8 even. We are on 11.
On 11, my lords,
Yes.
the answer is much narrower. The answer will be, if it is a rectifiable breach, your lordships in several judgments have indicated that that will not stand in the way when your lordships has to grant relief. One citation, my lords, is 2020 volume 11 SCC 1. Here, 2020 volume 11 SCC 1, Vijay Karya, that was under 48. The rectifiable, your lordships characterized it as a rectifiable breach.
What?
RBI approval was not taken and FEMA was being violated. And they said, you can't enforce this award today. Now, my lords, your lordship put to me, you violate the law and then you call it an affliction. My lords, somebody takes an award and it's violating FEMA. Your lordships have treated it, have characterized it as a rectifiable breach and said, this cannot stand in the way of enforcement of an award. So, my lords, when the expression is null and void, inoperative, incapable, my respectful submission is only this. A temporary affliction, a rectifiable breach would fall outside the sweep. It has to be something more. It has to be something permanent that attaches. Otherwise, my lords, it will not come within the sweep.
Enforceable till it is stamped.
Which is the second argument. Now, my lords, that brings me to the second argument in my note that starts at para 45. My lords, my submission is your lordships will see 3 aspects together. 1, in a series of judgments, your lordships have held that the Arbitration Act is a complete code. As to what is the connotation once a law is held to be a complete code, how it excludes the operations of other laws. There are several judgments I've reproduced in my note to assist your lordships. My respectful submission is, A, the Arbitration Act is a complete code. B, the Arbitration Act in Part 1, Section 11 falls under Part 1, has Section 5. In Section 5, Parliament has gone one step beyond the model law by adding a further non-obstante clause which says, notwithstanding anything contained in any other law for the time being in force. So Parliament is conscious there will be laws like the Stamp Act. Parliament is saying, I am making a complete code. I could have borrowed lock, stock and barrel Article 5 of the Ancestral Model Law which didn't have a non-obstante clause. It will create a problem because laws like the Stamp Act exist. Let me therefore add an additional layer of protection. And what is the text of Article 5? My lords, I beseech your lordships to see Article 5. Section 5, extent of judicial intervention. My respectful submission, my lords, is impounding a stamped document is also an intervention. It is an intervention by a judicial authority. The language is
No,
not,
ultimately, is it your argument that if stamp is not paid
my lords.
and the document is brought to the court,
Yes, my lords.
so court will refrain from
Two submissions, my lords.
impounding
Two submissions.
because the act says minimum judicial intervention.
Two
Is
submissions,
that
my
your
lords.
submission?
Two submissions, my lords, on that. Number one, at the stage of section 11.
No, forget at the stage.
Yes.
Whether
I bow down. What your lordships is asking, I'm
level of
answering
judicial
that.
intervention.
Yes.
We are on
So, my lords,
judicial
my answer is without pitching it beyond the level, because that would be pitching it, my lords, beyond what I'm trying to. I'll pitch it a little lower to say, as and when your lordships is exercising power under 8 or 11, it is judicial intervention, and the language of 5 is very clear. Notwithstanding anything contained in any other law for the time being.
It will not be judicial intervention in the first place. It's something through the judiciary.
Very well, Miles. We'll call it through the judiciary. In matters governed by this part, no judicial authority shall intervene except where so provided. My argument is so provided. What your lordships is asking, my lords, would be, I would be going beyond so provided. If your lordship gives meaning to the expression so provided, my respectful...
Section 37, section 34, these are what is contemplated by so provided. It is very clear.
Yes. So, my lords,
So
therefore...
that don't, beyond that, no.
Quite right. So,
right.
if at the
Not to
stage...
say that when an application to section 11 is filed, I mean, where is the question of interference there?
Well, that's for the reason, if
court is passing an order of refusing to pass an order based on the facts.
If your lordships, then my respectful submission is, suppose your lordships were to say that there is a Stamp Act obligation and we are enforcing it, your lordships would be travelling beyond section 5 is my respectful submission, because the non-obstante clause becomes redundant.
You understood.
Because-
What is the next point? Yes.
Yes.
Intervention in arbitration.
Intervention in arbitration creates the problem. That's
the
all.
11.6a.
Yes, my lords.
If it is found that no, there exists no arbitration agreement at all,
My lords,
how can you say that it is an interference with arbitration? There is no question of arbitration.
because my lords, the power that is, I would only say the
so
power
section
is...
5 says about the intervention in arbitration.
My lords,
See at 11.6a, what is the question to be decided?
quite right.
Once it is found that no arbitration agreement exists, then only the question of arbitration would come.
In your lordships, the answer to that... my lords,
Can
would
you
be-
say that that intervention, the word intervention, it means that the court cannot go into that question under 11.6a?
All I am saying is, the intervention, since it is happening once power under 11 has been invoked, it would go beyond so provided. That's all. And my lords, my respectful submission is, I have given certain citations. Kindly see, my lords, in my note at para 53. I'm only giving the citation. My lords, I'm not going further beyond that. Para 50, I have given judgments on section 5. 53, other judgments, like for example, in an election trial, your lordships have held when an election trial is conducted, we don't go to the CPC because it creates a problem. So I have given different illustrations of different acts when they are held to be a complete code and some other law is brought in and it creates a difficulty. Your lordships then says, since it is a complete code, we will not allow that to interfere in the working of this law. So those citations are at para 53. I have given examples of the Income Tax Act. I have given examples of election trials under Representation of People's Act. I have given judgments, my lords, separately. There's a local Calcutta law, for example, my lords, under 1993. I have also given example of the IBC. When IBC, my lords, your lordships is trying to do a corporate insolvency resolution process, so many laws start coming in the way. But your
Arbitration award, is it to be stamped?
no, my lord, there's a judgment of the Rio Glass. Foreign awards are not to be stamped.
You're talking about Indian award.
Indian award.
You are full of your
No, my lord.
foreign awards.
No, they're required to be. I
Required to
misunderstood.
be stamped.
Yes, my lords.
So the example we are putting to you is, suppose
Well,
there is an award passed,
My lords.
it is not stamped,
My lords.
it is put to execution. So it's a decree
Quite right.
without anything to be done.
Quite right.
Will the executing court be bound to execute?
My lords,
Or will it say section 5 we will not interfere? Judicial interference means we have to execute it.
my lords, what I would respectfully submit, what I would respectfully submit is the executing court would strike a balance. It would ask the entity who is seeking execution that do you want to secure it? But it will not say I will not do, because my lords, there may be a worse problem.
Therefore, stamp back therefore applies.
Milad, I am not for a minute saying,
You are
I am saying
saying
your
in the
lordship.
beginning that
Milad, that's why I responded to
Is it
the
not-
question saying, I am not pitching it so high to say the act doesn't apply.
Ah.
I pitched it lower to say I don't want to pitch it so
Minimal
high.
interference.
Your lordships will modulate using section
We'll do
5
that.
and the non-obstante clause.
Bound to do that. We'll do
Your lordship will modulate. So, my lords, which brings me to the last point, which is for Ashok traders, which is yesterday where when your lordship were rising, I had pointed it out, that judgment. My lord, that is also an example of a rectifiable breach. That was a case where section 9 was filed. The entire section 9 was sought to be
What is the
defeated.
citation?
My lord, that is 2004 volume 3 SCC 155.
155.
Now, my lord, there, para 13 of that judgment, section 69(2) of the Partnership Act is relied upon. They say this is a partnership deed. You are seeking interim measures arising out of a partnership deed. Sorry, the deed is not registered. We will not come to you. Court cannot come to the aid of the litigant. Court said doesn't matter. At the end of the day, since it is 9, we can extract the arbitration clause and look at it in by itself without getting fettered by the underlying document. Otherwise, somebody's right to relief gets defeated. So, my lords, all I'm saying is whether it is Vijay Karya, whether it is Firm Ashok Traders, whether it is Shinetsu, there are, my lords, parallels that are there in the law. And, my lords, your lordship will also bear in mind another example only, and that, my lords, is 1996 volume 6 SCC 660. Rectifiable breach or curable affliction, if I may say. Suppose a plaint is lodged in a manner where somebody is not authorized. Your lordships have carved out a distinction in that judgment to say you cannot ensure substantive rights are defeated and no injustice is done. So your lordships have said we'll allow you to cure it, but it won't stand in the grant of relief.
Very good.
All that I am submitting, my lords, therefore, is section 5 and the complete code argument
Yes.
can possibly give a middle way out.
Thank you. Thank you.
Grateful.
Yes. Now, whatever you have to say, Gaurav, we are looking forward to your.
My lord,
Mr. Banerjee, what I might ask, we've heard one side of the argument.
my lord, I just want to emphasize only 2 points, my lord.
Yeah,
One is 2G, something your lordships wanted some
that's right.
2G. And secondly, my lord, what is falling from the benches, arbitration is great, arbitration is good, we must, my lord, certainly, my lord, help it along, make the appointments. But why are we doing this by violating the law? Now, this is the point which is troubling your lordships. Are you violating, is the section 11 judge violating the Stamp Act by not impounding the instrument at the section 11 stage? My lord, the argument on the other side is a little circular. You can't violate the law. The Stamp Act is the law. You are violating the Stamp Act. You cannot do it. My lord, therefore, the predicate question is, are you violating the Stamp Act at the 11th stage or not? Everybody has assumed, my lord, that you are violating the Stamp Act at the 11th stage. My lord, I'll come to that separately. My lord, I just want to say this. My lord, it is nobody's case, that the court has zero role. Nobody's case, my lord, that at the section 11 stage, the court is acting as a post office, my lord. At least it's not my case, and it is not even the legislature's case that the court is acting as a post office. That may be the result, my lord, of the 2019 amendment. Maybe we are going to reach that very quickly. So, my lord, undoubtedly the court has a role. The question is, what is the extent of the role? This is one point your lordships will have to consider. Secondly, my lord, it is not that somehow by appointing, the court lets go of the matter. My lord, the court has the ultimate supervisory jurisdiction. The arbitration or the arbitrator is not above the court. Ultimate, whichever jurisdiction we go to, the supervisory jurisdiction is always with the court. Well, these are larger issues your lordship will keep in mind. So supervisory jurisdiction is always with the court. I would have submitted, my lord, and this is one aspect your lordships may consider, otherwise we'll have another 10 judgments on Article 11, that at the 16th stage, there is intervention under Article 16(3), my lord. That is something your lordships may consider whether the legislature may have a look at it or not. But in any event, my lord, at the 34th stage, the last call Assuming, my lord, the arbitrator goes haywire, assuming he acts on an unstamped document, assuming he doesn't hear anybody, etc., the last and conclusive call is always with the nobody is saying that the arbitrator is an errant can go free anywhere he wants. So, my lord, therefore, the only question is the scope of interference, or I wouldn't use the word interference. No, interference has a negative connotation. Scope of examination at the 11th stage, and whether by in my respectful submission, expanding the examination to include stamp is contemplated under 11(6)(a) or not. That's really the question. As I started, my lord, at the beginning, your lordships can take both. My lord, both views are possible. I had said that right in the beginning. I had also said, my lord, that NN Global was not correct. I had also said, my lord, and I want to address that first, that unfortunately, my lord, neither is Garwari and neither is Vidya Drolia, and the 2G analysis there is simply, my lord, inconsistent with.
What about SM?
My lord, SMS, there's a different problem, my lord. SMS may be a different problem, but certainly, my lord.
What is your contention?
My lord, I'll come to SMS separately, my lord.
Because
That's
to consider that also.
That, my lord, your lordship. So, my lord, there are two questions if I can formulate. One is, what is the answer to the reference? Question number one. Question number two, my lord, I will phrase it like this: whether the issue of examination and impounding of instruments, please note all words here, examination and impounding of instruments should be done by the 11th judge or should be left to the arbitrator. Those are the two questions, my lord, which squarely arise for your lordship's consideration. One, answer the reference. Two, answer whether this examination is to be done by X or Y. My lord, there's actually very simple answer on 33, which I have discovered pursuant to what your lordship said yesterday on the scheme, etc., which perhaps, my lord, will cut the Gordian knot, my lord, and maybe give an easier way out of 33 and 35, which may not require, my lord, great mental gymnastics. I'll come to that. There's a simple, my lord, I would say silver bullet, which answers 33 and 35. I'll come to that. Please first see the reference question. Well, let me, my lord, first deal with the reference question. Yeah. That is a question your lordships have to answer. Can you just hand it over? Lords, I have recast it and there's a reason.
Given a final bound.
But a lot of the issues your lordships have raised are covered in my spiral bound notes. Many of those issues are covered, but anyway. My lord, I have struck out which is not chargeable to payment of stamp duty. That is because, my lord, in my respectful submission, it is even an arbitration agreement is. And my lord, what I have now, there are three phrases which are used in the reference order. One is non-existent. Your lordship see that? Yeah. Non-existent. My lord, existence is a word which is relatable to section 11 and 16. Existence is a statutory word. My lord, I have added, and I will explain the reason for this, unenforceable in law. My lord, the reason I have added this is the expression in 2G. The word, my lord, unenforceable, your lordships will not find in the Arbitration Act. My lord, what your lordships will find in section 45 is incapable of being performed, null and void, inoperative, and incapable of being performed, whether unenforceable is covered by that or not, but that's 45 as your lordship, and nothing to do with it. So, my lord, the phrase I have used is unenforceable.
Where do you get the expression incapable of being performed?
45.
That is in
45. And that, my lord, was deleted. I have said it in my note, my lord, it's deleted. So, my lord, there were three concepts: null and void, which is void; inoperative, different; incapable of being performed, different. World Sports Group, my lord, is there in my note. Each of these have different meanings, three different concepts. So, my lord, is an unstamped document, my lord, is it non-existent? Is it unenforceable in law? Or is it invalid? My lord, I have added the word void because, my lord, invalid, again, validity, I would say, is a word which is used, my lord. Valid, my lord, the flip side would be void. My lord, there is no third expression, at least in the Contract Act. My lord, either is void, my lord, voidable we are not.
What is is there any procedural impropriety, in this reformulation? Is constitution
My
based?
lord, your lordships will have to I can't see any procedural impropriety, my lord. I mean, subject to,
Yeah, right, this is that.
sorry? It is, my lord, regularly reformulated, my lord, because ultimately your lordships have to answer the question. The question has to be answered. So, my lord, three expressions are there. Now, my lord, what your lordship put to me is the commentary in Mullah, where, my lord, this is mentioned. And please see, my lord, paragraph 22, 29 of Garwade
Garwade.
and 146 of Justice Khanna's. My lord, let us please spend 5 minutes because that has some relevance, my lord. I'm
Absolutely.
sorry to take a little bit of time on that.
Ultimately, it'll boil down to that.
These three at least let us see, my lord. And the 33, 35, my lord, I will find a rather simple answer, my lord, maybe simplistic, but a simple answer. I'll come to. Please see these three paragraphs. Lord, if your lordship take my compilation 1.
Which three judgments were relying
My
on?
lord, I am only looking at two judgments, my lord. 2 paragraphs of Garwade and 1.5 paragraphs, my lord, Vidya Grolia.
They are in the,
They are, my lord, in my first compilation reference, my lord.
it's there.
It's there, my lord, in every compilation, whichever one your lordship wants to look at.
Keep that.
No, I don't have a copy of their compilation, my lord.
No.
Unfortunately,
Pages may not match.
pages done. Anyway,
You're getting one.
I'm getting one. But in any case, your lordship, I can coordinate the pages. Please see paragraph 22 of Garwade. That is at page 25 of my compilation.
That's good.
Lord, please read 4 or 5 sentences here carefully without comment. I'm reading. Lord, first para 21, 2A, B, G, H is set out. Then please see, when an arbitration clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. My lord, no dispute. Absolutely correct, my lord. No dispute. Agreement, contract, enforceable by law, no problem. My lord, the next sentence is the problem. We have seen how under the Stamp Act an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. My lord, with the greatest of respect, not correct.
Wait.
Why? Right. My lord, please, let's read the sentence. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. My lord, the rationale of this bench is that till I stamp a document, it is only an agreement and not even a contract.
This is exactly.
My lord, this is the issue. Yes.
Bazir does.
Right.
But
Now, my lord.
when you see the effect in terms of the enforceability,
My lord,
is
this,
to be viewed from the prism.
my lord, this sentence.
What will a litigant do with an agreement which is not stamped if he wants to?
My lord,
is remedy
your lordship,
court of law.
my lord,
There is a point.
that point,
That's
my lord,
why- therefore it
that
becomes
is weighing, my lord, but my lord, that is not the language of the Contract Act. The Contract Act says enforceable by law if it is not enforceable by law.
Not.
If it is not enforceable by law, the consequence is it is void.
That's right.
Now, my lord, the question therefore comes to the point that if there is a agreement which is unstamped, my lord, let us leave aside the court for a moment. If it is unstamped and it is an agreement, the day the unstamped agreement is concluded, my lord, namely parties, consideration, etc., it becomes a contract. It is not void, my lord.
There you must bear in mind section 17.
My lord,
The Stamp Act.
my lord, where this distinction comes from, my lord,
Please
your
read
lordship
section
is
17.
17, my lord.
Got a bearing on This very issue.
My lord, 17 says, what your lordship says, 17 says that a document should be executed on a particular date. Right, my lord?
No. Can you read section 7?
I'll read
We
7.
have a-
But my lord, this is very, because the consequence,
It's important. What you raised is very important.
my lord, I want to clarify it. I want to show, my lord, that the Law Commission specifically addressed the issue of stamping
That's right.
and found that 2G operates in a different field. It's a very interesting observation by Mr. Setalwad's Law Commission, my lord, which deals with this issue. I'll show that. 17 is instruments existed in India. All instruments chargeable with duty and executed shall be stamped before or at the time of execution. There's no dispute about it. The question is, what is the consequence of non-stamping? The consequence of non-stamping on day one does not render.
Please read section 62 of the Stand Back Talk.
My lord, 62 is penalty, my lord.
Please read it.
I'll read it, my lord. That is also, my lord, dealt with. I'll show another judgment on 62 also, my lord.
Please read it.
60, my lord, I'm obliged.
Referred to it NM Global.
Not in NN Global.
Not referred to. None of these.
My lord, 62 is the penalty provision.
That's right.
Correct.
Just see what.
Penalty for executing, etc., instrument not duly stamped. Any person, my lord, not duly stamped, voting or attempting, shall be punishable with fine, etc., etc.
Why we ask you to read section 62? It's the conspectus of all these provisions, apart from the explicit language used. The conclusion is inevitable that it is absolutely imperative and mandatory. You
Well,
can have a situation.
I am not disputing
Okay, what you're saying
the
is-
mandatory nature of the, my lord, but, my lord, there's this but is there, my
It
lord.
could be directly. If it is directly, you are right.
But, my lord,
We have to first clear the air there. It is mandatory.
it may be mandatory. I am not saying, I am not arguing it is not mandatory.
That's
I am
right.
saying, my lord, we are at a situation, my lord, prior to curability. We are not at the stage of curability. My lord, it can be cured temporarily affliction. That's a secondary argument. My lord, I am on the first argument. The first argument is that the agreement, and that is why, my lord, I cited all those Calcutta judgments to show that even in unstamped document, my lord, the underlying agreement is valid in law. It is not unenforceable in law within the meaning of 2G.
It is not, it is unenforceable unless and until amends are made
My lord,
in known to law.
My lord,
If it remains unstamped,
my lord, it does not
Yes.
make it void.
no, what you're saying is, we are talking about unenforceable, not don't bring in void now, it will get a little bit more confusing.
My lord, because
We are
please,
con- just
please,
deal
my
with
lord,
enforceability. We are
please see
doing
the sentence. My lord, let me read the sentence again.
That's right.
We have seen how, my lord, I'm saying this is wrong as a proposition of law. Under the stamp agreement, an agreement does not become a contract.
That's right.
My lord, that's a huge leap. Because if that is the case, my lord, it will impact on all sorts of other, my lord, legislations. For instance, limitation. My lord, there are at least 4 or 5 such procedural laws where, for instance, there is an agreement and there is a bar of limitation. My lord, the examples given in Mullah. So, my lord, if now the court holds that an
What is the
agreement,
example with regard to limitation and
I'll show the Mullah commentary. My lord, limitation. I have got a copy of the Mullah commentary which I will show, my lord. My lord,
That expression is because, see the corollary of 2H.
sorry, my lord.
An
2H
agreement
there.
enforceable by law is a contract.
Right. So, my lord,
So,
either
if it is not enforceable, what it is?
2G.
It's not a contract.
2G, my lord. No. Please see 2G. An
H
agreement
also you-
not enforceable by law is said to be void.
You see H also.
H, my lord, no difficulty. Your lordship
An agreement
hold.
enforceable by a law is a contract.
My lord, your lordship.
Therefore,
Yes.
not enforceable. How it can be a contract?
My lord, it
That
has to
corollary
be.
is, that is the statement therein.
My lord, it has to. The question is this.
Vanity, the real question will be, what is the meaning of the word enforceable?
My lord, the word enforceable with respect, my lord, is not there in either the Contract Act or the Arbitration Act. It is there, my lord, in 45, which is unenforceable, my lord, not to be performed, etc.
That's right.
It is not there in 11.6a. It is not even there in 8.
We are asking you, what is the meaning of the word enforceable?
My lord,
Why we are asking that question? There is a reason. A contract is made by a party.
Correct.
Between two parties.
Correct.
Naturally, it can only be between two parties. It is required to be stamped. To make
Yes,
it duly
it is
stamped.
required to be stamped.
Take that, that's the example. Now, as you saw, the point of time at which actually it has to be stamped.
It has not been
No,
stamped.
17.
Not stamped.
It is not stamped. No, the parties may give and receive benefits, goods, services
Only, my lord.
without actually complying with the requirement of the second, whatever is the provision under the Stamp Act which mandates it, violating the time also, section 17.
17 is why.
They don't go to court.
They don't.
Just listen.
Right.
They may actually, under the shadow of secrecy, means that the light of day, it doesn't come down on this transaction at all. They perform this contract. Fine. It is absolutely fine.
My lord,
They're performing it.
No, no, there is still a
The
contract.
question is,
It's still a contract, my lord.
no, we are saying the enforceability must be determined with reference to whether if this document is produced in a court of law or a tribunal or a quasi-judicial body or a public office, what is to be done with that document will determine the question as to whether it's enforceable.
Those are questions of enforceability, admissibility, etc.
It cannot be acted upon by a court.
My lord,
Therefore, what you're trying to say is enforceability would be understood as that document cannot be the fountainhead of a claim in a court of law.
very well, my lord.
It cannot therefore be enforced.
Very well, my lord. So far, so good. But, my lord, but this sentence which says that the agreement does not become a contract, my lord, is considerably further than that. It has many implications because, my lord, why is it necessary to say this? Because then the next line is that since an agreement does not become a contract, it does not exist in law. To get over, my lord, 11.6a. So, my lord, if I can convince your lordship that agreement has become a contract, but subsequently may not be enforceable, my lord, it's a different situation. Please keep that distinction in mind. That's the same problem with para 146. Three things have been said in 146. Please see 146.
Yeah,
that is equally confusing. And then I will show your lordship the law commission specific to stamping, specific to the issue raised, and, my lord, the commentary in Mullah, which your lordship has already seen, to see what is the distinction that Mullah draws. And my lord, I will say that Mullah states the law correctly. There is no difficulty in that. Your lordship will see that also. Kindly see 146. I'm sorry, my lord, I'm taking little bit of time on this because this question was squarely raised, my lord.
So this has to be dealt with.
It has to be dealt with.
235.
146, your lordship will
We
see.
got it page 35 of the compilation.
235 of the page, my lord, 115 of the report, 149. May I read it, my lord? Please note there are any number of different ways this has been put, my lord. Please keep existence in one bucket, validity in one bucket, my lord, enforceability in one bucket. Everything has been elided in this paragraph. I'll show, my lord, three different sentences in three different places. We now proceed to examine the question whether the word existence merely refers to contract formation. And I would say it refers to contract formation as a matter of law. Namely, you must, my lord, fulfill section 7. I am not arguing that it is a waste paper, my lord. And so it will require contract formation if it is by an alien enemy or it is otherwise void because of a minor. My lord, certainly the court will, you will not appoint an arbitrator. So, my lord, to that extent, no difficulty. And excludes the question of enforcement validity. Now, my lord, how do you equate validity with enforcement? Validity, my lord, is a question of voidness or validity. That's how, my lord, 11 is, 16 is. So, my lord, enforcement is brought into validity, which is not there in 11 in any case. But anyway, on and then the judge realizes that there's a problem here. On jurisprudentially and textually possible to differentiate between existence of an arbitration agreement and validity, such an interpretation can draw support from the plain meaning of word existence. However, equally possible jurisprudentially to hold agreement has no existence if it is not enforceable and not binding. Well, there's this problem. It can be binding but yet not enforceable. So, my lord, again, two problems here. Existence of an arbitration agreement presupposes a valid agreement, no difficulty, which would be enforced by the court by relegating the parties. Legalistic and plain meaning, your lordship may leave. A reasonable and just interpretation of existence requires understanding context, purpose, relevant legal norms applicable for a binding enforceable arbitration agreement. Agreement, evidence, and writing has no meaning unless parties can be compelled to adhere. A party cannot sue and claim rights based on unenforceable document. Thus, there are good reasons to hold. This sentence I have no problem with. Thus, there are good reasons to hold that an arbitration agreement exists when it is valid and legal. A void and unenforceable understanding, again, my lord, we are on void. Void is equated to unenforceable. Is no agreement. Existence means arbitration. My lord, look at the last sentence. Meets and satisfies statutory requirements of both the arbitration agreement. Of course, it has to satisfy and the Contract Act. And when it is enforceable in law, my lord, enforceable in law goes back to 2G. So, my lord, everything here says 10 different things. So, my lord, I would beseech your lordships to keep enforceable in law separate from enforceable. And, my lord, this is a distinction which flows from a Privy Council judgment, which has been recognized by, my lord, the first Law Commission. 13th.
There are good reasons to hold that an arbitration agreement exists only when it is valid and legal.
Validity means, my lord, it's not void. Legal means, my lord, it is a concluded agreement. It can't be, my lord, that, but does that include, my lord, everything to the end? That's the question, my lord. We are looking at existence. We've not even got to validity. Whereas, my lord, 45 says void, inoperative, incapable of being performed. So, my lord, we have stretched it right across. Please see, my lord, the Law Commission, because this will answer the question. If it is held that an unstamped document is not an agreement, is not a contract, my lord, I can think of at least, my lord, 10 or 20 very startling results on that. If it's not even a contract, my lord, it will have very interesting implications. That means there is no concluded contract at all. Please see, my lord, the Law Commission's report, copy. And then I will show your lordship the commentary in Mullah, where this distinction is made. Now, this is the 13th report of the first Law Commission, MC Setalwad Law Commission, my lord. And please come, my lord, to para 26 straight away, which is at the bottom of the page. I want to read it a little carefully. The Director of Legal Studies, your lordship got this? Clause G?
We got it.
The Director of Legal Studies, this is the Madras Law College, has also made the suggestion that it should be provided in section 2G that agreements of imperfect obligations are not void but only unenforceable. He has mentioned an unstamped document as an instance of such a case. Such an instrument, which is a record of an agreement, is neither receivable in evidence nor can be acted upon. 35. Since the decision of the Privy Council in Mahant Singh versus U Bayi, which I will show to my lords, the law is well established that the expression unenforceable by law does not mean unenforceable by reason of some procedural regulation, e.g. law of limitation, but unenforceable by reasons of substantive law. In view of this, it is unnecessary to introduce the change. So, my lord, what the Law Commission was put to was the Madras gentleman said, please clarify the law that a unstamped is not void.
What if an arbitration agreement is made compulsorily registrable? Is registration a matter of procedure? Like, what would happen then if
my lord,
it's not registered?
If my lord, if it was compulsorily registrable, my lord, and the consequence of, my lord, there are two stages in any situation. No? One is what is the law, and two is what is the consequence. So, my lord, one, what is the law, mandatory, directly, nobody is running away from that. what is the consequence? If the implication of the law was that if you did not register, agreement would be void, my lord, it would stand on a completely different footing. And my lord, your lordship will just see that one passage in that Calcutta judgment only on this and on our Stamp Act. I'd shown this, my lord. Please see page 39 once more. All those cases, my lord, go the same way, but please see 39, compilation 3. My lord, because this is an academic discussion. We need to, my lord, either way, your lordships need to decide on. Let's get it. Mullah. My lord, just see page 39. Your lordship's got this ILR judgment. There are 4 or 5 judgments which say this. I am only showing one page.
Yeah.
39. Mr. Basu's first contention. Lordships have it. 39.
Yeah.
And so the document is not valid because it is not properly stamped. Then, my lord, 35 is set out. The effect of the section is to make such an unstamped document inadmissible in evidence and unable to be acted upon by persons having authority to receive evidence or by any public officer. It does not affect the validity of the document. There is a clear distinction to be drawn between invalidity and inadmissibility. Certain statutes and sections render documents invalid if they are not stamped. No section of the Indian Stamp Act has this effect, but an instance of a document being rendered invalid by omission is contained in the English Stamp Act. So, my lord, if the consequence which was provided in our Stamp Act was not 62, but a clause which said that if you have not stamped it, it is invalid, then, my lord, it would be void and then the consequences would follow. My lord, and that is the reasoning also in the other judgment, my lord, which I had shown your lordship, which is the PLD judgment. That's the entirety of the reasoning is only on this. My lord, your lordship will just note page 108 to 110 of that paperwork. My lord. So, my lord, this is so far as these 2 paragraphs are concerned. Your lordships have seen the suggestion made and the understanding of the Law Commission. My lord, and that is also the understanding in Mullah. Please see Mullah now. 2 pages of Mullah. My lords may just see Mullah page 111 at the bottom. The lordship has already seen this.
Yeah.
I could make out. But I had also photocopied it for the same reason, my lord. Please, it is actually consistent with what I'm saying.
Yeah.
The words not enforceable by law in this section do not refer to a disability to sue arising under any procedural laws like the law of limitation or civil procedure. The unenforceability contemplated in this clause is one arising under the provisions of substantive law, and my lord, the Privy Council judgment is quoted. Then please see the next sentence. It may be declared void by this act or by any other law. So, my lord, if the Stamp Act had said unstamped agreement is void, then certainly, my lord, it would not exist in law. There is no problem. But our Stamp Act, for whatever reason, does not go that far. Then, my lord, a contract void since is no contract at all. Then, my lord, what your lordship would have said, there is no existence of any agreement. We would go back from validity to existence and say, maybe it exists. In fact, it does not exist in law. For instance, my lord, a contract to resolve family dispute or divorce. that would be void at ab initio.
You have not completed reading that page.
Yes, I'll complete.
Important heading.
Sorry, my lord.
Unenforceability.
Sorry, my lord.
Unenforceability.
I'm reading unenforceability. I'm reading
That
that.
is
my lord.
important.
Of course, I've seen that. my lord.
That is important.
Unenforceable contracts are valid in all respects. So, my
That's
lord, that
exactly
is
what we were saying.
that's right. But may not be sued upon by the parties. Such a disability may arise for want of registration because the time prescribing the suit has expired. Firm has not been registered, or document does not bear the requisite stamp duty, or because lender of money does not put. So, my lord, this is the distinction.
Therefore, the distinction, if you were to go to a court of law or a tribunal or whatever, under the aegis of the state,
In general, my lord, there is no
you cannot
dispute.
impose it unless that, the
No difficulty.
The shadow is, removed.
My lord, that's the second point.
That's-
Whether 33 and 35 problem comes or not.
That's right. No,
Right.
we are on the general
My
principle.
lord, the general principle is
Forget about arbitration. Suppose
it is valid.
It
It is valid.
can be enforced unless and until you go 33.
My lord, it is. Let me put it.
Stamp duty.
My lord, it exists in law. It exists in law. It is valid.
In a manner of speaking.
My lord, that's
When
what.
you say exists in law,
My lord, existence.
it's a
It is. My
very
lord,
unique kind of a thing.
my lord, it is valid. It's valid, my lord. That's what it says. My lord, I am reading this. It is not unenforceable law. It is valid. It exists. It is valid. But as your lordship puts it to me, in the normal case, it cannot be enforced because there is a bar under 35.
33 also.
33.
You have-
33.
when you reformulated the question,
33.
you have not referred to 33.
33. I agree.
33 is important because 33, the moment this document is produced before,
No, that's where I have a different submission.
it is obliged. Justice Ravindran said.
No, that is where I would beg
It
to
is bound to impound it.
slightly differ on.
What happens to the
My
transaction?
lord, just there is exactly what, my lord, I would like to differ on two counts. My lord, my lord, therefore, this sentence with respect in paragraph 22 and 29 may not be strictly correct because it is enforceable in law. It exists in law. The two, my lord, 22 and 29, this is not the effect of the Stamp Act. The formulation.
May not be enforceable. We are trying to elicit a reply from you.
Will
It
not-
not be enforceable in the sense that as an unstamped document cannot.
No,
be-
that's the second part. I am only on, my lord, I have to first get
The
over.
parties, we told you, the parties may actually.
So, my lord,
opt
to-
there. If you
to
read
that,
section-
all I'm saying is, to
Give
that
me an
extent-
example. Please read section 8 to the contract. Act.
Section 8.
8 to the contract. Act.
Acceptance by performing conditions or receiving consideration. Performance of conditions or acceptance of any consideration for a reciprocal promise which may offer proposal is an acceptance of the proposal. So, my lord, there is.
Why we asked you to read this is, see, the parties performing the contract may begin even at the stage after the proposal is. How do you begin a contract? How does it lead to formation of a contract? Somebody makes a proposal, person called proposer, promise, accepts, consideration, agreement. These are the, how an agreement.
Lord, I'll put it.
What you're saying is, persons may perform. We have no difficulty about
Lord,
that.
may see 10.
But then,
Please
if
see
you
10.
enforce it,
My lord, please see
it
10.
remains unenforceable.
Please see 10. Please see 10 and read para 22 and keep them together.
That's,
It will not work, my lord. That sentence will not work with para 10, with section 10.
That's right.
My lord, it may be your lordships may arrive at the conclusion which the other side wants, or Justice Ravindran's conclusion without incorporating this reasoning. I am first demonstrating, my lord, this reasoning is wrong. Then, my lord, the second question, whether you are the court can go ahead violating law. That's the second question.
even there we are saying it is not enforceable what Justice Nariman says.
My lord, please see the sentence again and please keep.
It's not enforceable.
That's not what he says, my
He
lord.
said you can't unless you remove the shadow
My lord may just
of
see.
it being unstamped or insufficiently.
That is what he could have said. But that's not what he said, my lord.
Huh?
That's not what he said. That is what your lordships are saying. That may be a
Okay,
reason.
let us put it that what I am saying,
My
what
lord,
we are saying.
can I read that
What's your
sentence?
answer to that? Because
That's the second question, my lord. I'm coming to that. Let me just, my lord, just see the sentence. I'll show the sentence again. My lord. 22.
Right.
My lord, agreement does not become a contract.
Sorry.
unless the document is stamped, agreement does not become a contract, namely that it is not enforceable in law.
That's right.
Now, my lord, namely that is not enforceable in law,
Right.
please cut out. And instead of enforceable in law, my lord, put the word void.
We understand where you're going.
So, my lord, that is not consistent with 10. So far, so good, my lord. So, your lordship, my lord, this reasoning may not justify the conclusion. That's all I'm saying. My lord, I still have to deal with SMS. Now, my lord, the short question
Does
is,
the word void always carry the same meaning in law?
my lord, 2G, my lord, void has a particular meaning in the Contract Act. Void has that meaning, my lord, right through. Validity is also an expression used in the Arbitration Act. My lord, it can't be semi-void, my lord. It can't. It's either, my lord, it's void or it's, my lord, not void. If it is not void, it may be unenforceable. That is what your lordships are putting to me. But certainly it is not void. It may be unenforceable. That's a separate, my lord, limb.
Can an unenforceable agreement be said to be existing?
Yes, my lord. It is existing in law. It is a contract. It exists. The moment I signed it, my lord, and I give, unless the statute, my lord, prohibits it. It exists. Between me and him, it exists. In law, there are obligations which I am in law required to perform, my lord. Even if it is unstamped, that obligation is still there on me, my lord, which I am required to perform. It's
So
a
you
non.
don't perform your obligation. You don't perform your obligation. You said you have obligations.
Well, no, then you get to the next stage of unenforceability. But it's a contract.
So when
It's
it
a
goes
valid
to court,
contract, my lord.
Therefore, it is unenforceable.
My lord, I am not saying that it's not unenforceable. I am only saying that, my lord, I have to get to first, my lord, I have to get over paragraphs 22 and 29, where the learned judge realizes the problem, my lord.
Yes.
Because the word is existence. The word is not enforceability. So he has to get to existence. To get to existence, you have to say it is
Void.
It's void. But that's too much of a leap.
Mr. Banerjee, perhaps what you have said so far, Stamp Act does not say that it becomes invalid.
Correct.
The document exists.
Correct.
Now, certain obligations are to be done, like stamping.
Right.
Now, if it is not stamped, then maybe consequences of not being enforceable may come in.
Including, my lord, punishment also. Supposing.
Penalty, of course. But then does not mean that it is a void document.
That's right. This is my assumption.
Or it does not exist.
That's right. That's the assumption. Now, my lord, I go to the second question. The second question which is bothering my lords is that how can we be, a gun to our head be put and said that no, just ignore the Stamp Act. Just simply ignore the Stamp Act in the interest of arbitration. My lord, that's the question. Why should we as a court condone a breach of law? This is the question, my lord, which is put, squarely put, my lord. To which my answer is, my lord, it's a circular question because everybody assumes, my lord. I will show, my lord, I will answer this in two ways. My lord, one is that there is, just, my lord, should I just tender that Privy Council judgment?
Certainly.
That
1939.
Yes, just page 113, just to complete the, which is the judgment required. My lord, the question presumes that by the judge referring the matter to arbitration, he violates 33. It has to be done, my lord, instantaneously. Correct? This is what has been put against me. My lord, there is an assumption that I am violating the law. My submission is that, and I made this before, my lord, and I'll give now two reasons why I say this, my lord. We are still.
Bear in mind section 8 also.
Section 8 also. Section.
Rhodia says 8 and 11 are
Right.
alike and similar.
Both, my lord, the logic will be similar, my lord. My lord, one is that there is two submissions, my lord.
Yes.
Two submissions, my lord. One is that there is an inconsistency between 11.6a and 33(2), both cannot operate. 11(6)(a) and 33(2), both cannot operate. 11(6)(a), and this is a point, my lord, which has been pointed out, my lord. I had pointed this out earlier. It is there in intercontinental waterline in paragraph 29, one of the subsequent judgments, my lord, that if the 11 judge has to do the exercise under 33, he necessarily has to go and look at the substantive agreement. My learned friend gave the example, the guidelines, etc. So the necessity of looking at the substantive agreement comes from 33(2). That's his job. But my lord, that job is beyond the job in 11(6)(a), which is restricted to examination of the arbitration agreement alone. So, my lord, one, I've already argued that. My lord, but there is a much more fundamental point which only came to me when your lordship raised this issue about the scheme. If your lordship sees the scheme and
You have not you have not. Which portion you wanted?
my lord, page 113, it is there in the, it's there in
That's
the,
the case where the question was I think the failure to sue within a time
right, my lord.
that would not make it the contract unenforceable.
Correct.
That's
So, my lord,
absolutely right.
my lord,
That is a different issue altogether.
my lord, the parallel is very similar, my lord. It doesn't make the, my lord, it's not a question of making the contract.
It will not make the contract unenforceable.
My lord, the contract, again, my lord, your lordships are depriving the party of a remedy.
That's right.
Here also, the same thing, your lordships are depriving the party of a remedy. So, my lord, it is in that sense,
Are you visited with any penalty for doing that?
yes, my lord,
Like in the Stamp Act?
yes, 61, 62, penalty.
No, we are talking about in respect of somebody's failing to sue for.
Your substantive rights go, my lord. I'm not sure that, my lord, any penalty is.
It's not a case of an unstamped document. No.
No, it's not a case of an unstamped.
It's a question.
It's a limitation, my lord. The parallel, the law
What
commission.
you say, by analogy.
Yes, that's what my lord Mullah says. That's what the law commission on that basis, my lord, did not clarify 2G. It does not cover void. Even the law college lecturer said, professor said that it is an imperfect obligation, doesn't make it void. Even he was saying the same thing, my lord. So, my lord, whichever way this was the judgment referred to in the commentary and the, my lord, explanation I am mentioning.
Good.
My lord, the parallel is right exists, remedy goes.
Remedy goes.
Remedy goes.
Exactly.
Remedy goes.
That's it.
So, my lord, this is the limitation, right exists, remedy goes. Here also, Stamp Act, right exists, remedy goes. My lord, here, of course, remedy goes temporarily. There, remedy goes permanently.
Permanent.
Right. So, my lord, that may be a slightly different case, but it doesn't make it void. That's all I'm saying. Now, my lord,
Here there's a difference. Here, the course to be followed before your right is being extinguished, that is also mandated by statute.
what your lordship is saying is that I'm answering the second question. What is mandated by statute?
Mandated by statute is your
33,
at that
my lord.
moment of time you cannot enforce it, but court will take it,
My lord,
send it somewhere.
I'm obliged. My lord, that is what is that point in time? Is that point in time when the matter comes before the 11 judge, or is that point in time when the matter comes before the arbitrator? That's the question, my lord.
Ultimately, that's right.
Right. Now, my lord, when the matter comes before the learned judge in 11, he deals with it as per the 11 scheme. Please now see the scheme.
Mr. Banerjee, why is it in section 8 and section 11 brought in by the same amendment we're taking?
Correct, my lord.
Slightly different wording.
I'll explain, my lord. I'll explain, my lord. Lord, I have some internal knowledge of this. 8 and 11, the law commission wanted to use the word null and void, inoperative and incapable of being performed, which was, my lord, the legislature had a rethink and curtailed 8 to some extent and curtailed 11 even to a greater extent. Well, there are some file notings as to why it was done, but nothing of it is on record. But the fact is that the legislature went one step beyond the Law Commission's recommendation by narrowing the field. So, my lord, today the question is how wide will your lordships open the door? That's the expression Justice Nariman used. The door was wide open in 11.
In Drodia, the three judges bench has equated section 8 with 11.
Right.
Virtually.
My
The
lord,
distinction in phraseology, what you're trying to tell is
my lord, there are 2 points to
validity, prima facie validity under the valid does not exist is what section 8 says. Now, section 11 doesn't refer to validity at all. It just says
existence.
So, Drodia actually has
Expands existence to include validity.
validity.
Right. My lord, it
So
does. There's an issue there. There's an issue there. But, my lord, the reason it equates it, again, we go back to para 29 of the Law Commission report. There are two issues. One is, what is the scope of inquiry? What are the arguments you will permit? That may be narrower in 11 and wider in 8. But the standard of prima facie may be the same in 8 and 11. So, my lord, that there is no problem. Prima facie standard of 11 has been read, 8 has been read into 11.
We not really understand section 6A as being incorporated for dealing with a particular evil. As
My lord,
or
right. What was that evil?
That evil was the view being taken by
My
the
lord,
court, including in SPP. And
the view, my lord, what the evil was a simple evil. The evil was that the door was open. That door has now been
And
possibly, my lord, narrowed.
And the specifics of those, the way the door was.
My lord, I have some.
The
Law Commission has mentioned two. My lord,
it is referred to in the Law Commission.
my lord, the Law Commission has mentioned two judgments.
That's right.
But the section says, notwithstanding any judgment, my lord, there has been discussion post the Law Commission and before the section has been introduced, which is not there before, my lord. So, my lord, the section says, notwithstanding any judgment, it is this concept, my lord, that somehow it is restricted. The amendment is, my lord, why was the amendment made? Let us not be blunt about it. The legislature did not want the courts to look at too many issues. That's why they did it. They've gone one step further in 2019 and said, now thank you very much. Let's get institutions to a point, which is the case in, my lord, Singapore and my learned friend was citing those Stamp Act. They are not relevant because there the institution appoints. So, my lord, the mischief rule, if your lordship wants, is that the entire purpose of 11.6a was to narrow the field. SBP was the 7 judges. So, my lord, that was the elephant in the room. My lord, one has to get beyond the SBP mindset. It was to narrow the field.
Exactly.
Now, my lord, when you narrow the field and bring it down to existence, the question your lordships are putting to me is, in the process of deciding existence, should we not also decide stamp act? This is the question. This is the question.
Are we not bound?
Are we not bound? If your lordships are not bound, then your lordships may not do it. Correct. Now, my lord, how I'm answering that question, my lord, in 5 minutes. My lord, please see the appointment of arbitrators by the Chief Justice of India scheme. Please.
We got it.
Yes. My lord, what is to be submitted under the scheme? And I'll give your lordship a practical example of NN Global. Please see the scheme. And this is something your lordship pointed out to me yesterday.
That's right. Yeah.
This is a statutory scheme. And I believe, my lord, this is in our enthusiasm and my enthusiasm, my lord, to argue large points. And one misses, my lord, a more simple, straightforward answer. Now, my lord, the purpose of 11, my lord, it's a summary proceeding, whether before or after SBP, whether judicial or not, my lord. my lord, it is at page 65.
Yeah, we got it.
Scheme may be called so and so, and there is similar schemes, my lord, in the High Courts also. The request, it's a request to the Chief Justice
Or
under
certified copy.
or a certified. Now, my lord, right. So, my lord, before you come to this court, in 99.999% of cases, and my lord, the reason is also there. If your lordship sees Order 8 of the Supreme Court Rules 2013, the copy has to be certified by the AOR. So, my lord, nobody files any original. It is sufficient for exercise of 11 jurisdiction to file a copy.
Absolutely.
Now, my lord, what is the consequence of that?
Yeah.
My lord, the consequence of that in very simple terms, there is a constitution bench in Karamchand Thapar, which your lordships may be familiar with, which has been consistently followed, my lord, by 5 judge, 3 judge, 2 judge.
That
Is
will not apply in a copy, in the case of a copy.
that, my lord, a copy is not an instrument. If a copy is not an instrument, my lord, 33 will not apply. Neither will 35. That's the short answer. What the consequence of that I'll come to. So, my lord, if I, in every case before my lords, there is a typed copy with a signature by the OR,
We come to paragraph 20 of SMS.
SMS.
SMST.
SNS. In fact, my lord, I'll go one step further. I'll go one step further, my lord. The court, even a fully constituted court, cannot compel a party to produce the original unless he does it voluntarily, my lord. In fact, in NN Global, what happened was, I don't know, the direction may be 142 or whatever, my lord, the party was directed to produce the original and have it impounded and stamped. Today, my lord, in an 11 before my lords, there is no document which is required, no instrument which is required to be impounded. And my lord, this makes perfect sense. When there is a trial, when there is a document, when there is an exhibit,
Paragraph 20, please.
20.
Paragraph 20 at
The scheme requires an application, so and so by. In fact, such a requirement is found in the schemes of, if what is produced is a certain.
just a moment. Please. Paragraph 20.
Right, my lord. May I read? It's very important. It's very important.
Because it's been interpreted by this court, that's
Right.
why we are telling.
The scheme for appointment requires an application under Section 11 of the Act to be accompanied by the original arbitration agreement or a duly satisfied copy thereof. In fact, such a requirement is found in the scheme rule of almost all high courts. What is produced is a certified copy containing the arbitration clause. It should disclose the stamp duty that has been paid on the original. Well, this is an addition by the court. My lord, it is not there in the scheme. Section 33. My lord,
This is what we are trying to point out to you. Even if it is a certified copy, the requirement of law has been
My lord,
declared by this court.
in a
That is how
certified.
it was being done.
Maybe, my lord. But your lordship is laying down the law on this, my lord. And if a certified copy is filed before my lords, my lord, the question I ask myself is this: is it an instrument? No, it's not an instrument. It is not the stage at which impounding will normally take place. Ex facie, there is no violation of 33 and 35. This concept that you must, my lord, the document comes and like tigers, my lord, we must impound, may not be, my lord, stricto sensu, my lord, what is there. That stage will come. Nobody is going away from that stage. That stage will come when substantive rights are thrashed out and the document is exhibited.
What will happen to a Section 8 application? Because there you have to produce the original.
Or certified copy. Or certified copy.
No, Section 8.
8 also certified copy. Same problem.
Certified copy is permitted.
Yes.
Is it permitted?
Yes, my lord, it is permitted. My lord, in every high court, my lord,
How, Section 8, we are talking about 8. Where is it permitted?
Yes,
How do you say it is?
provided that where the original arbitration agreement or a certified copy thereof is not available with the party. In fact, Section 2, the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. Then the proviso comes in.
so my lord, we cannot be certified.
Certainly, because under Section 90 of the Evidence Act, 91 of the Evidence Act, Sorry, 60.
My lord, your lordship is right, 91, read with 60, that the
Original
implication.
document must be produced.
Contents of the document, that's not document.
Secondary evidence is
Yes.
produced. into the-
Secondary evidence, my lord, normally is not permissible.
Not permissible.
Not-
Unless you
but my
create
lord,
foundation.
secondary evidence is permissible in a section 11 situation.
You're right.
So my lord, so this problem that we are, my lord, building up to such a level, my lord, frankly will come when the court is confronted with the document. And the document,
Banerjee, just to take it forward, you said that I had a simple answer. I was looking at the
Scheme.
wood and I was missing the trees.
right, my lord.
You see, the scheme, it talks about an original arbitration agreement or a duly certified copy thereof.
Correct.
Now, that is not something which is impoundable.
That's not impound.
And what is also provided in this SMST state in paragraph 20, as just Joseph has pointed out,
Right.
it should disclose the stamp duty that has been paid on the original. So it has to disclose the stamp duty. The court in section 11 is not something which is impoundable.
I am obliged. And therefore, my lord, 33 will not kick in at that stage. 33 will kick in at when, my lord, when actually you are, my lord, going, my lord, proceed on. And that is why, my lord, that GT said judgment I showed, my lords. I'll show that again, which is section 9, where the court, my lord, finds that I have to look at this agreement. I can't impound it. Therefore, please pay security. In an interim relief, my lord, how does the court, and the section 8, somehow the court will protect, my lord, but that will come as a condition of the, my lord, interim relief. So, my lord, where is the bar in 33? I submit, my lord, that bar can legitimately be postponed to the arbitrator, because he will have to, my lord, look at the substance. Let us take this example forward, my lord. This is an unstamped document. I am the arbitrator. I will simply say that this is an unstamped document. It can't be stamped. I will not take it into account at all. If you voluntarily produce it, have it stamped, we go ahead. But that is a decision, my lord, to be taken by the arbitrator and the voluntary nature. Please see what happens in NN Global. You are forced to produce the document. You are forced to pay 8 lakhs, which you say you shouldn't pay, and your bank, and it is impounded by the registrar, and your bank guarantee goes. My lord, this is the implication. If today in 11, your lordships are to decide all the issues which my learned friend said, how much is the stamp duty, who is the right party, who is to bear the amount, etc., even albeit on a prima facie basis, my lord, I would respectfully submit that the door would be a little wide open, which perhaps, my lord, was not really the intention. My lord, I'll just show, my lord, I would put it in a different way. Your lordship says, is it a court to receive evidence? Or I would say that it is not a court to receive evidence in that sense. It's a summary court which can take within its fold even a photocopy, of course certified. So, my lord, whichever way your lordship looks at 33, and it's a fiscal statute, it has to be read strictly. If I can get out of it, then it's between me and the government. Then it is, the court will, my lord, not go overboard to protect the government. It's a fiscal statute, it has to be read strictly. If there's
Become a tax collector.
sorry, my lord, court is
Do not become a tax collector.
so, my lord, before the arbitrator, the original will be called for. My lord. It has to be called for if you want some substantive relief. And if it is not, the arbitration will end.
That constitution bench
Right.
said about
My lord, what I have done is, my lord, there are
Upper.
Karamchand. My lord, what I have done is, there is one judgment of Justice Sanjeev Khanna in the Delhi High Court where he traces the full history. Constitution bench, 3 judges, 2 judges, etc. That one judgment. My lord, I am taking. There's also a Bombay High Court judgment, but I will show that separately if required. What happened in this case was that there was a development agreement between 2 parties. The photocopy of that was shown to the collector. The collector said, produce the original, show cause to produce the original, and impound and pay penalty. So, my lord, collector court holder the document and said, now you must pay. In that context, my lord, what the High Court does is, the lordship first sees paragraph 15. Section 14, my lord, starts with 33.
Yeah, 62 Supreme Court.
Yeah, 60. My lord, it is 19. We've given the list. 1962 1 SCR.
It's available in 62 Supreme Court,
Yeah.
110.
Yes,
Yeah.
my lord. It is quoted, my lord. Paragraph 6 is quoted.
I
That,
think we just want to see that.
It's-
Yeah, 62 Supreme Court.
my lord, it is 1962 is the same judgment. 62 1 SCR.
Yeah, Supreme Court. 110. Yeah.
62 1 SCR. No, whichever one your lordship wants to see. 827. It's the same, Karamchand Thapar. There, my lord.
This argument would apply only if a certified copy is produced, of course. This argument that you're building up on the basis of the scheme, if the original document is produced,
My lord, if the original document is produced, my lord, in the extremely unlikely event that that's not
what will happen in the arbitration if also he produces only the certified copy?
finished, my lord. The arbitrator will say, I will not go into this at all.
Produce the original.
He will have to produce the original. So, my lord,
How do you admit the document?
my lord, that will be at that. There's no difficulty, my lord. I am not saying Stamp Act will not apply, my lord. I am only postponing, my lord, the event.
Yeah.
One of the last portion. So this judgment actually quotes all the 3-4 judgments in one. So that's why I had given it.
Yeah.
This is, your lordships have the AIR or the SCR?
SCR.
SCR, right at the end, page 834. It starts at 834. It is next contended. That's the passage which has been set out by Justice Khanna and the judge.
You may read, we can follow from the quoted part that is already there in.
It's already there, my lord. It's the same quoted portion. And all the other judgments, my lord, if it is an original agreement, my lord, I would then fall back on my argument on 33 2 versus.
Examine.
Now, my lord, if it is an original agreement, which is only the arbitration agreement, my lord, I may concede that arbitration agreement, but that is, my lord, 5,500 rupees. It's
Nobody is going to.
So, my lord, the practicality is, my lord, threefold. Original arbitration agreement produced only standalone, perhaps, my lord, there may be an issue. Anything else, my lord, it has to go to the arbitrator. My lord, also what fell from my lord Justice Rastogi, if there is a doubt as to the extent of the stamping, that, my lord, also is, once prima facie case is seen, that also should go to the arbitrator. That is, my lord, Weatherford? No, Interline. That was the view taken in that 3-judge bench, that, if there's some dispute regarding stamping, then also, my lord, in Vidya Jolia, it should go.
What the court really held was the copy could not be validated.
Correct. Copy cannot be, my lord, validated. Validated.
Copy, because the facts, you have, that's why we wanted to see this judgment.
My lord,
There is a decree, because that was, I think, an award.
my lord, a copy, in fact, my lord, the law is that a copy is not an instrument.
It was found to be the original.
Yes, it was, they got around it, my lord, they said, yes. So, but, my lord, there are a number of judgments after that. An instrument under 214 has to be the original instrument. That is the understanding of 214 of this court. My lord, it cannot be, because even, my lord, even if you purport to impound a photocopy, you cannot, by paying stamp duty, cure what is incurable. So, my lord, that's a different scenario. That's a separate situation. In a photocopy, there are extreme cases where you lost the original. and you say you've lost the original and photocopy is there and you are willing to pay. And even then, my lord, some courts have taken the view that that is barred under the laws of evidence. So there are extreme views like this.
Good to hear that you're using the word incurable.
That is, my lord, incurable where it is a photocopy.
That's right. We thought
If it's a photocopy.
that's right.
But, my lord, I am simply saying that 33 and 35 will not engage at this stage because you don't even have the instrument before you. So, my lord, that's the problem. In the virtually all cases, because of the Supreme Court rules, my lord, a certified copy is put up and that is sufficient. Nobody, my lord, wants to put in a doc. So even
Supreme Court rule is original or certified copy.
no, my lord. Please
is
see
so.
the rule. Rule is certified copy.
Original or.
Please see the Supreme Court rules 2013, 8.
Okay.
Rule 8.
Rule.
Rule.
Not the scheme.
Not the scheme is original certified, but the rule is in the normal case, my lord, and that is common sense, my lord, that this court does not want to be burdened with original documents at the stage, except when there's a full-fledged trial or there's a 131 suit, when you then, my lord, proceed and summon exhibits, mark. Similarly, my lord, in a suit, when it comes, order, my lord, when the question of impounding comes, is when the documents, my lord, are filed, the original is placed before the judge, then he takes a call then. Nobody takes a call, my lord, on day one. There's a judgment of Justice Balakrishnan saying that merely when you file, that's not good enough. It has to be, my lord, something which my lord, it has to be exhibited, acted upon, etc. So, my lord, my simple point is, let them go past 11. Please leave it to the arbitrator. Please trust the arbitrators. They are, my lord, after all, the alternative dispute resolution, unless your lordships find that there is an insuperable mandatory bar, which then, my lord, of course, substantive law of India, mandatory bar, don't look further, impound. If that is the law, my lord, then of course, my lord, then existence will mean something, my lord, much more than the narrow meaning of Justice Korean Joseph, which says narrow meaning, no more, no less, my lord. Then it will be more rather than less. Then your lordships will have to decide what is the stamp duty, etc. Those are my subjects.
What do you say about this last argument of that? Or based on the scheme, certified copies?
Yes, well, certified, yes, I will take it, yes, that the certified copy is a photocopy, the original agreement. The photocopy, the certified copy means what? It's a photocopy of an original which will
And one more
show.
thing, you wanted to say something about SMC.
SMS.
My lord, SMS, the problem is that this aspect, my lord, according to me, my lord, it may not be necessary to decide the rightness or wrongness of SMS.
The prior to.
Yes, but in any event, my lord, there also this argument of 33 and 35 that impounding will require the original may not have
And what do
been.
you say about his argument about, that fiction not being carried further than it's required?
My lord, fiction,
About the divisible.
my lord, I am not argued divisible, my lord. Fiction is, my lord, only relevant only so far as 11.6a limits it to arbitration agreement. So it's consistent with that. That's all. I am not saying that fiction overrides the Stamp Act. We are not arguing that the fiction, my lord, overrides some third law. Those 10 judgments, my lord, whatever they say, they say. My lord, I would again, my lord, at the end request your lordships, my lord, just to see the last 2 pages of my written submissions, because I believe that there is a balance, and also that your lordships may consider, since it is a constitution bench, and whatever your lordships say will be seriously taken by the legislature to introduce this, my lord, control in 16. My lord, it's like a water bottle. If you don't give control in 16, you press hard and everything flows to 11. So we have this 11 jurisprudence going on from time immemorial. Somewhere people want justice, my lord. Whether it is unstamped, whether it is whatever it is, my lord. And that justice is now being postponed till the end. After 1.5, 2 years with 34. So, my lord, if there was a 16, I am confident, my lord, none of these matters would have come. Or maybe, my lord, we are so litigious, still it would have come up, but then your lordship would have given a simple answer, go to 16, sort it out, we'll come back in a.
Yes. Thank you.
Thank you.
You have spent so much of time and energy. We should be thankful.
Not at all, Manoj, it's my privilege.
The expression used is original arbitration of a duly certified copy thereof. I would take it to be a photocopy of the original arbitration agreement, which is either on the stamp, e-stamping as we call it, or wherever separate stamp papers are used, the stamp papers also are included. So entire thing duly certified, which will show what stamp duty has been paid, if any. That is in the sense, it is used in SMS. If what is produced is a certified copy of the agreement, contract, instrument containing the arbitration clause, it should disclose the stamp duty that has been paid on the original.
But can you invoke 35? That's
Because in my
question is whether you can the whole idea of
in my experience, when you read 33
and 35.
33, 35, and
If a certified copy load is produced, how can the court involve? How can the court, there is a question of evidence that they act upon it. The scheme itself and the rules permit a certified copy.
let us go to verse 33. 33, it says instrument.
What's your answer?
Verse 33 and 35 both talk of instruments which are the original instruments produced. What difficulties? 33 and 35 words is followed by 38 where it is impounding how to be done. Now let's assuming that the certified copy has been filed and this discloses that no stamp duty has been paid.
Correct.
Well, certainly not the court can call upon because this was done in SMS.
You have to match it with this Karamchand Thapar judgment.
Yes,
If the original instrument is not here,
yes.
we cannot
Let's
impound the certified copy.
please bear in mind that in NN Global, the operative order Roman 2, the Secretary General was directed call upon us to get the document, the original document before the court, and then get it impounded.
No.
And then it was
Whether the legislature has vested us with that power means
if we see
in a global that course has been taken.
Whether it's contemplated under law, that's only question. Whether this is contemplated, if certified copy is permitted, ordinarily the original document alone is permissible under the Evidence Act.
61, 62, 64.
Correct. But here the law itself says you can do this, like you read out section
Yes.
8.
63 and the scheme also.
That's right. Therefore, when the original is not produced, certified copy is produced, you agree it is not an instrument falling within the meaning of the word section 34, 33 and 35.
250.
No, no,
And the judgments
33 and
also,
35.
there are two judgments which says photocopy. Yes, I
That's
will.
right. Whether there is then this ancillary or supplementary or additional power to when you find stamp duty is not paid or not adequately paid to call for the document and then impound it and then send it. Is it contemplated in law?
Yes,
My lord, if I may just add one line, my lord, the word is examination in section 33. I just also.
Examination of the instrument.
Absolutely, my lord.
Examination of the instrument is the instrument in original.
So, my lord, my only point is that it can be after the certified copy if it is seen that it is insufficiently stamped or not stamped. The instrument can be called for. And then, my lord, thereafter the rest of the proceedings would follow.
It can be called for or has to be called for.
My lord, it should be called for if it has to be proceeded.
Now, where do you get that should be?
My lord, I am only reading the section 33, my lord, and I'm also reading para 20 as my lord pointed out from SMS to say this.
My lord, the High Court judgment which I have shown says, my lord, you cannot call for it. 48, my lord, there are sections in various Maharashtra acts where the collector could perhaps call for it, but that has been interpreted by this court. The court suo motu cannot call for it. Voluntary act. You cannot force some.
What we had built up on a huge mountainous scale. If this had been the premise,
My lord,
traveled from section 8. Section 8 photocopy was filed. And here type
Section
copy
8
was.
also permits certified copy.
Yes, section 8 also permits certified.
Ordinarily, in a proceeding, only the original can be produced.
Let's,
And
if
the
we,
stamp act, etc., comes in when the original is produced.
yes.
let's instrument if we see the
Here we have a
reference.
different kind of regime.
This
Well, I had not seen this until yesterday when your lordship had pointed to the scheme. Then my lord, this point came in.
just see the definition of instrument, 214 in the stamp act. Instrument includes every document by which any right or liability is done. So it is an inclusive definition, document. The original does not say, but there is a judgment here of this court.
It's a very strange way of, how things happen because this principle is supposed to get at somebody who's producing a certified copy and trying to validate the original document.
Right,
It is that which is not permissible.
Right.
But, in twist of fact, here it works against you because you cannot come
You can produce it.
stamp duty.
The document was called from me.
You follow what you're saying. Or supposing somebody were to produce the original and seek to validate it. Under section 35, by paying the duty, you can't do it with a copy. You have to it's possible only if you have the original. This is what has been laid down there. But here it's a sort of double-edged sword as it were, and it's working against.
Yes, I will only point out one thing.
Yes, we have to write. So we have heard sufficiently, and I think
Only just one thing, timeline is section 20,
Only one thing, ultimately the argument is that you are trying to defeat the Indian law on recovery of stamp duty. But the argument, if we accept the argument that is put forth, we are not defeating that. Eventually that is being collected. I mean, there is no question of stamp duty not being covered.
Very deeply obliged for this patient hearing.
My lord, there's one judgment.
That's enough.
Just need
yes, yes.
this one.
Rest of the matter will come on Tuesday.
Deeply obliged.
Very
Thank you.